My mother told me I had no instinct for law. She said it at the kitchen table on a Sunday morning when I was 16 years old, still in my pajamas, reading a case file I had printed from a legal database I wasn't supposed to have access to. She said it again at Christmas when I was 19, and told the family I wanted to go to law school. She said it to her book club friends over wine loud enough for me to hear from the hallway that my older brother Daniel was the one with the sharp mind, the one who could argue both sides of anything before breakfast, the one who would carry the Mercer name into the kind of legacy she had always imagined. I was the soft one, the emotional one, the one who felt things too much to think clearly. 7 years after I left that house with a duffel bag, a paralegal certificate, and $300 borrowed from a coworker, a letter landed on my desk. A real estate development firm in Phoenix, Arizona, was facing a federal breach of contract lawsuit that would cost them everything. Their legal team had collapsed. Their lead counsel had withdrawn under circumstances nobody was explaining clearly. They needed emergency representation by the end of the week, or a judge was going to hand down a default judgment that would bury them. The firm was called Mercer Crane Development. The founder listed on the letterhead was my mother, and she had absolutely no idea who ran the firm she was begging for help. The meeting was scheduled for Thursday morning. My conference room, my office, my city. My mother would walk through the door of Aldridge Legal Group in downtown Chicago, sit across from me, and ask the daughter she said was too emotional to think like a lawyer to save everything she had built. I had 2 days to decide what kind of attorney I wanted to be when she found out. I need to tell you how I got here. Thursday started the way most Thursdays started for me. I was at my desk by 6:30, half a cup of coffee in, reviewing a motion brief before the building filled up. I liked the early hours. The stillness of a law firm before the phones start ringing carries a particular kind of weight, like the silence between a question and an answer. I was a senior partner at Aldridge Legal Group, 42 attorneys across 3 offices, ranked in the top 20 civil litigation firms in the Midwest 2 years running. I had earned every inch of that ranking. My assistant, Priya, came in at 7:15 carrying a case file and an expression I recognized immediately. The kind she wore when something had arrived that she wasn't sure how to hand me. She set the file on my desk. Federal breach of contract, Phoenix-based development company. Emergency representation request. Opposing counsel is Hartwell and Burke. That's significant, she said. They don't take small cases. I already knew the name on the cover sheet before I touched it. Something in the way Priya was standing told me. She had been with me 3 years. She knew things about my life that I hadn't said out loud. Mercer Crane Development. I picked up the file. Kept my face neutral. My hand didn't shake. I had spent 7 years teaching my hands not to shake. The case summary was 40 pages. I read all of it. Mercer Crane had entered a $34 million commercial development contract in 2021 with a construction consortium. The project stalled. Mercer Crane alleged force majeure and supply chain delays. The consortium alleged deliberate misrepresentation and breach of fiduciary duty. The original defense firm had billed $280,000 and then withdrawn, citing a conflict of interest that nobody in the file explained. A federal judge had given Mercer Crane 14 days to retain new counsel or face judgment by default. 14 days had become 4 days. A $34 million exposure. No legal team. I flipped to the leadership section. Founder and CEO. Patricia Mercer. I stared at my mother's name. The way you stare at something you thought you had locked in a room you never intended to open again. She was listed with a headshot I hadn't seen before. Older than I remembered. Her hair was shorter, completely silver now, cut close around her face. She was wearing a blazer, the color of deep water, and a small, careful smile, the smile she wore when she was performing competence for a room full of people she needed to impress. I had watched that smile my entire childhood. I knew the exact amount of pressure it required to hold. Second name, Daniel Mercer. Vice President of Operations. My brother, of course. I read Daniel's bio without slowing down. Arizona State, business degree, joined Mercer Crane in 2019. led the Scottsdale mixed-use expansion, led the residential partnership initiative, led the Southwest Commercial Corridor strategy. 3 major efforts. I cross-referenced each one against the financial exhibits in the case file. The Scottsdale expansion had run 40% over budget and delivered 8 months late. The residential initiative had produced 2 partnership agreements, both of which had since dissolved. The commercial corridor strategy was the subject of the current lawsuit. 3 ventures, all with Daniel's name at the top, all producing outcomes that had walked his mother's company to the edge of a cliff. The brother my mother said had the sharp mind, the one she built her entire succession plan around. I set the file down, walked to the window, looked at the city. Chicago in October is gray, and certain the sky the color of unfinished decisions. I pressed my forehead against the glass and felt the hum of the building. Part of me said send the standard response. Decline for capacity reasons. Let Mercer and Crane find another firm. This was not my problem. I had not spoken to my mother in 7 years. Not one phone call on my birthday. Not one text when I passed the bar. Not one email when Aldridge made me partner at 29, the youngest in the firm's history. 7 years of silence from Phoenix. But another part of me, the part I had learned not to trust, because it was always right, felt something else. Something cold and precise and patient. 7 years of patience, sitting in a room at the back of my mind, waiting. What would it feel like to sit across from her? To watch her explain her crisis to the daughter she said was too emotional to navigate one. I walked back to my desk, picked up the phone. Tell them we can meet Thursday morning, I said to Priya. In person. I want their full leadership present. Everyone listed as an officer or principal. She'll ask why, Priya said. Tell her we require a comprehensive intake session before we can assess representation eligibility. Priya paused. One more thing, I said. When you contact them, use only my first name and title. Elena, senior partner. No last name in the correspondence. No firm bio attached with my photo. Any reason? I like first meetings to stay focused on the facts of the case. Priya didn't ask again. She had worked with me long enough to know the difference between a question and a wall. After she left, I sat alone with the file. I looked at my mother's name on the letterhead. I thought about a Sunday morning kitchen table, a 16-year-old girl with a printed case file, and a mother who looked at it for approximately 4 seconds before turning back to her coffee and saying, "Honey, law isn't about feeling. It's about detachment, and you have never been detached about anything in your life." I had spent 7 years proving that sentence wrong. Now the woman who said it was going to walk into my conference room and ask me to save her. I had 2 days. I intended to use them. To understand what happened in that room Thursday morning, you need to understand where the sentence came from. Not my mother's mouth. Earlier. It started with a girl who was 12 years old and furious about an injustice she didn't have the words to name yet. The summer I was 12, our neighbor Mrs. Castillo was being evicted. She had lived in the house 3 doors down for 22 years. Her landlord had sold the property, and the new owner wanted her out in 30 days. She knocked on our door on a Wednesday evening, hat in hand, asking if my father knew anyone who could help. My father was a contractor. He didn't know any lawyers, but I had been to the library that week. I had found a pamphlet about tenant rights. I sat with Mrs. Castillo at our kitchen table for 2 hours and walked her through every right she had under state law. She stayed in that house for 8 more months before a proper agreement was reached. My mother told the story at dinner like it was a funny anecdote. Elena found a pamphlet, she said, smiling. Isn't that something? Daniel, sitting across from me, had not looked up from his phone. I was 14 when I told my mother I wanted to be a lawyer. She was driving me to school. She didn't take her eyes off the road. That's a lot of pressure, she said. It requires a very particular kind of mind. Daniel is the one who can argue both sides. You feel everything too deeply. That's a gift, sweetheart, just not the right one for law. I didn't say anything for the rest of the drive. I looked out the window and filed the sentence somewhere low and permanent, the way you file something you're not ready to act on but not willing to forget. At 16, I started reading case transcripts on my own. I found a legal database through a school library login that probably wasn't intended for student use at that level. I printed cases. I annotated them. I had a 3-ring binder by the time I was a junior in high school, with tabbed sections by area of law: constitutional, contract, tort, property. I showed it to my mother once. She opened it, flipped through 2 pages, and said, "That's very organized, Elena. Have you thought about paralegal work? It's stable, and you'd still be part of the process." Paralegal work. I was 16. I had a 3-ring binder with color-coded tabs. I closed the binder, went upstairs, did not bring it out of my room again. At 18, I was seated at the Thanksgiving table. My mother had arranged the seating the way she always did, Daniel adjacent to her, at the center, and me at the far end near the kitchen door. Her sister had flown in from Tucson, 2 family friends. The table was loud and warm and smelled like the rolls my mother only made when she wanted the evening to feel significant. My mother stood with her wine glass. She did this when she had something to announce. "I want to say how proud I am," she said. "Daniel has been accepted to the Accelerated Business Program at Arizona State. Full merit scholarship." She looked at him with the expression I had spent 18 years trying to earn. "When he's ready, there is a place in everything I'm building for him." Her friend looked across the table at me. "What about Elena? She's the legal one, isn't she?" My mother smiled the careful smile. "Elena is our compassionate one. She cares deeply about people, which is a beautiful quality. But law requires a kind of armor she hasn't quite built yet. There's a place for that too. Just a different kind of place." The table moved on. I sat with a letter in my jacket pocket, an acceptance letter from Northwestern University's pre-law program, partial scholarship, which I had received 3 days earlier, and had told no one about because I had wanted to see my mother's face first. I put the wine glass down carefully. I ate the rest of the meal without speaking. I showed the letter to my father that night in the hallway. He read it twice. He pulled me into a hug that lasted longer than it needed to. He didn't say much. He wasn't a man of many words, but he pressed the letter back into my hands and said, quietly, "Don't you let anyone talk you out of this." My father passed away 18 months later. Heart attack. He was 54. At the funeral, my mother gave a eulogy that talked about the family he had built and the legacy he had left. She talked about Daniel's future with the company. She looked at me once, from the podium, and her expression was the same expression she always had when she looked at me, something between affection and gentle disappointment, as if I were a project she had started, and then decided wasn't worth finishing. After the service, at the house, my mother's sister found me in the kitchen and held my hand and said, "Your father was so proud of you, you know. He talked about you all the time. He told everyone at his job that his daughter was going to be a lawyer someday. I didn't know that. He had never said it to me out loud, and now I couldn't ask him to." I left for Northwestern 6 weeks later. My mother drove me to the airport and hugged me at the curb. She held my face in both hands in that particular way. She had careful, deliberate, like she was memorizing something she expected to lose, and she said, "Call me when you get settled." I called her from the dorm that night. She asked if the room was nice. She asked about the weather. She did not ask what I was planning to study, or what I hoped to build, or whether I was scared and also thrilled the way you are when you step into a life that finally fits. She told me Daniel had just signed a lease on an apartment in Scottsdale. She was helping him furnish it. I said, "That sounds nice." I hung up. I looked at the small room I was renting with a futon and a lamp, and I thought, this is where it begins. Not there. Here. I threw myself into Northwestern the way people throw themselves into things when they have something to prove, and have not yet learned that the only person they're really proving it to is themselves. Pre-law. Then law school, DePaul University College of Law, merit scholarship. Top 5% of my class. Law review, moot court. An internship at a federal public defender's office that rearranged how I thought about justice at a molecular level. A clerkship with a federal judge in Chicago. Then an associate position at Aldridge Legal Group, where I had stayed and risen and built something I was not going to apologize for. 7 years. Not one call from my mother asking how the bar exam went. Not one text when I made partner. Not one email that said I was wrong about you. Nothing from Phoenix. Until a 4-day emergency landed on my desk with her name on the letterhead. I worked through Tuesday and Wednesday building the intake framework. I had Priya pull everything publicly available on the Hartwell and Burke complaint. I read the original contract. I read the construction consortium's filings. I read the deposition transcripts from the discovery phase that Mercer and Crane's prior counsel had managed to complete before withdrawing. By Wednesday night, I understood the case. Hartwell and Burke were good. The complaint was tight. But there were 2 significant gaps in their damages. Theory places where the causation chain had soft joints, where a skilled litigator could introduce doubt. The prior counsel had missed both of them. That was why they withdrew. Not a conflict of interest. Incompetence they couldn't walk back without exposure. They had left my mother with a burning building and called it a conflict. I also understood something else by Wednesday night. The contract at the center of the lawsuit had been negotiated and signed by Daniel. The misrepresentation allegations, the core of Hartwell and Burke's complaint, were tied directly to representations Daniel had made to the consortium in writing. Emails. 3 of them. Specific claims about project readiness, financing commitments, and timeline guarantees that the evidence suggested he either knew were overstated or should have known. The brother my mother said had the sharp mind for business had put his name on statements that were now being characterized as fraud. I sat with that for a long time in my office Wednesday night. The city outside, the lake invisible in the dark. I thought about the letter in my jacket pocket at Thanksgiving. I thought about the pamphlet for Mrs. Castillo. I thought about a 3-ring binder that nobody asked to see. Then I closed my laptop and went home, and slept 4 hours, which for me is nearly a full night. Thursday morning. 6:15. Conference room B on the 14th floor. I arrived before anyone else. Long table, 12 chairs, windows facing north. I sat at the head, placed my hands flat on the table, looked at the empty seats. In less than 3 hours, my mother would sit in one of them, my brother in another. I did not rehearse what I was going to say. I rehearsed stillness. The ability to sit across from the woman who had looked at my 3-ring binder and suggested paralegal work and hold her gaze without flinching, without needing her to see the irony before I was ready to show it to her. At 9:47, Priya's voice came through the intercom. Your 9 o'clock is here. 2 principals. Patricia Mercer and Daniel Mercer. Give them 5 minutes to get settled. Then come get me. I used those 5 minutes at the window. Lake Michigan in October is flat and gunmetal and enormous. I thought about my father saying, don't let anyone talk you out of this. I thought about 7 years of not letting anyone. I thought about a clerkship and a bar exam and 42 attorneys and a ranking in the top 20. Then I buttoned my jacket and walked to the conference room. I opened the door, and there she was. My mother was standing at the far end of the table, older than I had allowed myself to picture. The silver hair from the headshot. The same careful posture she had carried my entire life, shoulders back, hands composed, the performance of a woman who does not let rooms see her nervous. She was wearing a blazer I didn't recognize, and earrings I did, small gold ovals she had worn to every important occasion since I was a child. She had worn them to my father's funeral. She looked directly at me and smiled the professional smile, the one for rooms full of people she needed. Thank you for seeing us on such short notice. I'm Patricia Mercer. This is my son Daniel. We appreciate your firm's willingness to review our situation. She extended her hand. I took it. Her grip was the same. Firm, efficient, the handshake of a woman who had spent 30 years in rooms where grip mattered. I had held that hand 10,000 times in my life, crossing parking lots, at school plays, at my father's graveside. I knew the ring she still wore on her right hand, her mother's ring, the one she said she would leave to Daniel because he was the one starting a family. I knew all of it and she knew none of it, and the room between us was made entirely of that distance. Welcome to Aldridge, I said. Please sit down. Daniel came forward next. My brother was 41 now, broader than I remembered, the kind of broad that comes from comfort rather than effort. He had their mother's eyes and their father's build, and none of either parents' instinct for when a room had shifted. He shook my hand with the ease of a man who had never needed to be anything other than the most expected person in the space. Good to meet you, he said. I took my seat at the head of the table. Priya settled behind me with a notepad. My mother and Daniel sat across from each other, halfway down the table on either side. The dynamic of a family that still arranged itself around an absent center, my father's chair, wherever they went. I said nothing for several seconds. I let the quiet hold. Then, tell me what happened. My mother told the story the way she told every story, organized, linear, confident in her own version. The project had been moving forward. The supply chain disruptions were real. The financing delays were industry-wide, not specific to their firm. The consortium had acted in bad faith by withdrawing rather than renegotiating. The prior counsel had failed to build the evidentiary record in time. She was good. She had clearly told this version many times. She made Mercer and Crane sound like a victim of circumstances rather than the author of them. Daniel added details when she paused. He spoke in the same abstracted language my mother used. Challenges became industry pressures. Mistakes became miscalibrations. The 3 emails at the center of the complaint became good faith representations based on available data at the time. I let them finish. Then I opened the case file and said, Mr. Mercer, I'd like to ask you about the representations made in your March 14th communication to the consortium's project director. Daniel shifted slightly. My mother's expression didn't change. The email stated that all municipal permits for Phase 2 were in hand. They were not. 2 of the 4 required permits were still pending at the time of that email. Is that an accurate characterization? There was a timing issue with the municipal. I need a yes or no first, then the context. A pause. Long enough? Yes, he said finally. They were pending. Your May 7th email stated that the construction financing for Phase 2 had been secured through a committed lender. At the time you sent that email, had a commitment letter been issued? Daniel looked at my mother. My mother was looking at me with an expression I had never seen on her face before. Not the professional smile. Not the careful performance. Something quieter. Something that was beginning to work its way toward recognition. We had a term sheet, Daniel said. A term sheet is not a commitment letter. It was industry standard to characterize. I set down the file and looked at my mother directly for the first time since the handshake. The characterizations in those emails are the foundation of Hartwell and Burke's fraud theory, I said. Your prior counsel didn't withdraw over a conflict of interest. They withdrew because they had built a defense on representations they eventually realized they could not support. They left you with 4 days and no runway, because the truth of what those emails say is not easy to defend. My mother was very still. Her hands were flat on the table. The gold earrings caught the light. There are 2 significant weaknesses in the opposing damages theory, I continued. I found them last night. Your prior counsel did not. That doesn't mean the case is winnable, it means it's not automatically lost, which is different. But I cannot do anything useful for you unless I have the complete truth about everything that happened. Not the version you've prepared. Everything. Silence settled over the room. My mother looked at me for a long moment. A look that had started somewhere in the middle of my description of the permit status and had been traveling slowly toward something I could see arriving in her face. Something that was not yet recognition, but was approaching it, from a great distance. Then she said, You remind me of someone. 3 words. Not an accusation. An observation, careful and involuntary, the kind of thing that slips out before the filters engage. The room was quiet. Priya had stopped writing. Daniel was looking at his hands. I set down my pen. I did not rush what came next. I had not rehearsed the words, but I had lived inside them for 7 years, and they came the way things come when you've been carrying them long enough. When I was 12 years old, I said, There was a woman in my neighborhood who was being evicted. She knocked on our door on a Wednesday evening. I found her a pamphlet at the library and sat with her at our kitchen table for 2 hours explaining her rights. She stayed in her house 8 more months because of those 2 hours. My mother thought it was a funny story. The girl with the pamphlet. My mother's mouth had opened slightly. Her hands had gone still in a different way, not composed still. Arrested still. At 16, I built a 3-ring binder of annotated case files, organized by area of law. When I showed it to my mother, She suggested I consider paralegal work. At 18, I was accepted to Northwestern University's pre-law program on a partial scholarship, and I sat at a Thanksgiving table and did not tell anyone because I already knew how the sentence would end. At 26, I passed the Illinois bar. At 29, I made partner at this firm. I am currently the youngest senior partner in Aldridge Legal Group's 41-year history. The room did not explode. It contracted. My full name is Elena Marie Mercer. You named me after your grandmother. I grew up at 4 Sycamore Court in Mesa, Arizona. My father's name was Robert. He told the people at his contracting job that his daughter was going to be a lawyer someday. He never said it to me out loud. He died before I gave him the chance to. My mother made a sound I had never heard her make before. Not a word. Something below language. Her hand came up to her mouth. Daniel looked at me, then at my mother, then back at me. His face had gone through 3 distinct phases: confusion, calculation, and finally something that looked like a man watching a building he thought was structural begin to lean. "Mom," he said quietly. My mother's eyes were wet. She had not cried at my father's funeral. She had held the performance all the way through. She was not holding it now. She said my name the way she had not said it in 7 years. "Elena," and then, "How long have you known it was us?" "Since Tuesday morning," I said. "When the file landed on my desk, you didn't send it back." "No." "Why?" I let that question sit for a moment. "Because there are 71 people employed by your firm who do not know that your son's emails are the reason their jobs are in danger. They didn't negotiate that contract. They didn't make those representations. They just work there." I saw something move across my mother's face that I did not have a name for. It was not gratitude. It was not relief. It was something older and more complicated, the expression of a woman who was for the first time seeing the shape of something she had been facing away from for a long time. Daniel said nothing. He was looking at the table. I stood. I buttoned my jacket. "I'm going to need you both to come back tomorrow morning," I said. "I'll need complete documentation, every email, every internal memo, every communication between Daniel and the consortium from the beginning of the contract. Nothing summarized, nothing filtered. If I'm going to find a path through this, I need the whole picture, not the version you've been presenting to each other." My mother stood. Her hands were not entirely steady. "Elena," she stopped, started again. "I don't know what to say to you." "Not yet," I said. "That's all right. Tomorrow, 9 o'clock. I walked to the door, opened it, held it. My mother gathered her things slowly. The deliberate movements of someone who needed the task to stay upright. Daniel stood. He looked at me as he passed, and his expression was the expression of a man who had been told, for the first time in his life, that the ground he was standing on was not solid. At the doorway, my mother stopped. She turned. She looked at me across the length of the conference room table, the way she had looked at me across the length of 17 years of Sunday dinners and Thanksgiving tables and airport curbs, but differently now. As if she were finally looking at the same thing she had always been seeing but had, until this moment, been refusing to focus on. She said, "Your father was right about you." The door clicked shut. I stood alone in the conference room, 14 floors up. The lake outside the windows, flat and gray and certain. I stood there for a long time and let those 5 words settle into the space where the other sentence had lived for years. Your father was right about you. It was not an apology. I knew the difference. But it was the first honest sentence my mother had ever said directly to me, without an audience, without a performance attached to it, and it landed in a way that nothing I had spent 7 years building had quite managed to. I was not finished. There was a case to build, and it was not going to be easy. And my mother's company was not saved yet, and might not be. But I had said what I had to say. And I had said it from the chair at the head of the table, and I had not needed her to hand it to me. I picked up the case file. Went back to work. The next 4 weeks were the most technically demanding of my career. The case was genuinely difficult. Hartwell and Burke were well-resourced and well-prepared, and the emails were real, and the problems in them were real, and there was no version of the defense that did not require confronting those problems directly. I built the defense on the 2 gaps I had found Wednesday night. The first was in the opposing damages calculation. Their expert had used a baseline that overstated the consortium's projected returns by applying industry averages that did not account for the specific market conditions in the wine, Phoenix corridor at the time of the contract. We brought in our own expert. The second gap was in the fraud intent element. Intent to defraud requires knowledge of falsity at the time the statement is made, and we found internal consortium communications from the same period that suggested their own projections had been equally optimistic, which undercut the clean hands position Hartwell and Burke needed to sustain the fraud claim. It was not a complete defense. I told my mother that plainly. What we were building was a basis for a negotiated settlement at a number that would not end the company. But first, I needed Daniel to stop performing. He came in for prep sessions 4 times over those 4 weeks. The first 2, he gave me the version, the good faith representations, the industry pressures, the characterizations that were standard. By the 3rd session, I had stopped accepting it. I'm not your audience, I told him. I'm your counsel. The difference is that I am not here to believe you. I'm here to understand what actually happened and build the strongest possible case from those actual facts. If you give me the performance, I cannot help you. If you give me the truth, there may be something I can work with. He sat with that for a long time. Then he said, I knew the permits weren't in hand when I sent that email. I thought they'd come through before anyone noticed. I wrote it down. I didn't react. What about the commitment letter? We had a verbal indication from the lender. No letter. I thought he stopped. I thought if the project moved fast enough it wouldn't matter. I wrote that down too. Why didn't you tell your mother? A long pause. Because she'd been telling everyone for 3 years that I was the one who could handle this. That I had the instincts. He looked at the table. I didn't want to be the one who proved that wrong. I recognized the shape of that sentence. I did not say so. We settled on the 31st day. Not a complete victory. There are no complete victories in cases built on emails that say what those emails said. The settlement reduced the exposure from $34 million to $9.2 million, phased over 30 months. The fraud claim was dropped in exchange for the reduced damages agreement. Mercer and Crane would survive. 71 people would keep their jobs. The day the settlement was signed, my mother called me. Not Priya, me, directly, on my cell phone. She had found the number somewhere, I didn't ask how. Thank you, she said. You're welcome. A pause. Longer than it needed to be for a transaction. I owe you more than that. Yes, I said. You do. She made a sound that was not quite a breath, and not quite a word. I'm not ready for that conversation, I said. But I'm not closing the door on it. That's something I've had to decide for myself. She said, I know I told you that you were too emotional for law. I have thought about that sentence a lot in the last 4 weeks. What did you conclude? That I said it because Daniel needed to be the one who succeeded. And I had already decided he was. And you or she stopped. You were making that harder just by existing the way you did. I sat with that. It was not an excuse. I think she knew it wasn't. It was just the truth, stated plainly, in the voice of a woman who had spent a long time learning not to use that voice. I told her, that sentence cost me a lot. I'm not going to pretend it didn't. I know. But I built everything I have without it needing to be different. And that's mine. She didn't give me that and she couldn't take it. Another pause. She said, Your father would have come to every one of your cases if you'd let him. I know that now, I said. I should have told him he didn't need to wait to be invited. She said, So should I. We didn't speak again for 3 weeks. When we did, it was a short call. Careful. 2 people building a bridge with borrowed materials over unfamiliar ground. It was not a reconciliation. I don't know if it will become one. Some doors open slowly and some open only partway, and you learn to work with what the light lets through. Daniel called once. He didn't offer an apology directly. He said, I didn't know you were that good. I said, I know. He said, That's not. He stopped. I know it's not enough. I said, It's a start. That was all. It was enough to work with. For now. I kept the case file in the bottom drawer of my desk. Not as a trophy, as a reminder not of winning, but of what I had chosen to do with the power when I had it. I could have sent the file back to Phoenix without a response. I could have let the default judgment come down and watched the company dissolve and called it justice. I had genuinely considered it. I didn't do it for my mother. I didn't do it for Daniel. I did it for the 71 people who had not been in the room on any of the days the wrong decisions were made. The ones who showed up every morning to a company they had not built and had not broken, and were not going to be given a warning before it disappeared. I did it because I had watched my neighbor, Mrs. Castillo, lose sleep over an eviction she hadn't caused, and I had been 12 years old with a library pamphlet, and I had known even then that the law is only worth what you choose to do with it. My mother told me I was too emotional for law. She was not entirely wrong. I do feel things too much. I feel the weight of 71 jobs and one woman's 30-year lease and a father who said proud things to his coworkers that he never said to me out loud. I feel all of it. I just learned how to build with it instead of against it. That's the only armor I've ever needed.